this is Ellen and Howie here with another educational video on the difference between revocable and irrevocable trusts. How? Start us off.
So we get asked quite often, what is the difference between a revocable and an irrevocable trust? And with a revocable trust, it's exactly as it sounds. You can revoke the trust, but when you dive deeper, you understand better how it operates. So the fact that you can revoke the trust also means that you can amend the trust and decide if you want to change who the trustees are. And it's really just a see-through entity where you have a receptacle to hold your assets. And the purpose of doing a revocable trust is to plan for your incapacity so that if you become incapacitated, then somebody else, the trustee, can manage your assets. And it also avoids probate upon your death. Now, the irrevocable trust, on the other hand, does the same thing, except that it's irrevocable, which means that you cannot amend it. And in most irrevocable trusts that we use in the elder law planning construct, you are not the trustee. The grantor of the trust, the creator of the trust, is not the trustee. So you are giving up control over those assets, whereas in the revocable trust, you still maintain control over those assets. And they're used differently because with a revocable trust, the assets are fully countable for Medicaid purposes, but with an irrevocable trust, the assets are not countable for Medicaid purposes after the applicable 5-year look-back period expires.
So this discussion obviously assumes that our audience knows what a trust is. So just to take a step back for a second, we're assuming that you understand that a trust is a legal document and it has terms of how the finances or the assets that are titled in the trust are managed. Whether it's a revocable trust or an irrevocable trust, it starts and it is governed by a legal document. So I think what a lot of our listeners would want to know is, what about the taxing structure? Or what about other creditors, not just Medicaid? And how can we use an irrevocable trust and still get favorable taxing structure?
So there is this concept known as grantor trust status. It's a concept under the Internal Revenue Code. And if you place assets into an irrevocable trust, even though you've given up control over those assets, if we set it up correctly, we can still make sure that the tax consequences of the assets in the trust are taxed at the individual's lower tax rates, not the trust tax rates, which are a much more compressed, we say, or higher tax rate schedule, so we can achieve favorable tax benefits that way. The other thing that we're able to do in an irrevocable trust is if you put your home into the trust, there's an exemption from the capital gains tax on the sale of one's primary residence. It's $250,000 for an individual who sells a home, and it's up to $500,000 for a married couple. If we set up the irrevocable trust correctly, we can preserve that exclusion so that even though you've put the home into the irrevocable trust, if the home is subsequently sold, as long as it still is your primary residence, you can still get the benefit of those tax exclusions.
And for many clients, their home is their largest asset. So that step up in basis or that tax benefit is really great and is very worthwhile for the client to achieve. So another thing that we hear all the time is there a threshold amount of assets that someone has to have in order to set up a revocable trust? We also hear, oh, I want a revocable trust because it avoids probate. So yes, we know that a revocable trust avoids probate, but to what extent? Meaning, how was it funded? And what about this threshold basis?
So there really is no legal threshold to set up a trust. If you have $1, you can put it into a trust. Now, I wouldn't recommend you do that because the cost of setting it up needs to be taken into account, of course, and there are some administration expenses as you go along and even upon your death. I would say if you didn't have more than maybe $20,000 to $50,000 in that range, I don't think we're going to be talking about doing a revocable or an irrevocable trust. But if you have that amount of assets, and also don't forget, a lot of people, like you said, their primary asset is their home, and usually that's worth at least, $100,000, $250,000, $500,000, what have you. So even if that was your only asset, you might still be considering doing one of these trusts, even if your cash assets were not very high.
And how do you avoid probate? What do you have to do in order to ensure that you avoid probate?
And this is a common problem, whether it's a revocable trust or an irrevocable trust. So a lot of times we meet with clients who proudly display for us an existing trust, and then as we pour through the bank statements, we learn that the trust has never been funded. So what does that mean, to fund a trust? What people need to realize is that when you sign the trust, that's only part one of the process. Part two of the process requires that you retitle each and every asset that must go into the trust, because the assets don't walk into the trust by themselves. So that requires going to each financial institution, requesting ownership transfer forms, completing those forms, and seeing this process through to a new statement that shows that the trustees of the trust, or the trust itself, is listed as the owner of the asset, not the individual who created the trust.
Oftentimes we get calls from clients, typically not our clients because we do funding with our clients, but other clients who say, well, my husband or my wife just died, but we had a revocable trust, and then when we dive deeper into the assets, there was an investment account that wasn't titled in the trust, and it was titled in the spouse's individual name. So even though they may have paid for a revocable trust, they still have a probate.
Yeah, I was just going to say, and unfortunately, sometimes in those cases, the account has maybe $1,800 in it, or a small balance, and it's such a shame because they did everything right, they set up the trust, they wanted to avoid probate, but now all of a sudden there's an asset that has to go through the probate process, and it's not in all cases even worthwhile to do that.
So we hope that this has given you a basic understanding of the difference between a revocable trust and an irrevocable trust. It's a complicated legal topic, so to learn more about it, we look forward to seeing you at a consultation in the office. Stay safe.